Hi, I'm Michael Cohen, and I'm joined by Don Crawford Jr., who always has such good insights on anything that we talk about. So we're going to continue our YouTube series here, as we've been doing, and on podcast, which we've been doing the last couple months after the radio show stopped, that we had done for many years. So we're going to continue that trend, and we appreciate those who are joining us here today. Um, Today's topic is going to be on John Amos, who passed last year. Um, John Amos, for those who don't recall, he was on Good Times. He was also in Roots. He was a famous actor. And he died, but his two children are in a lawsuit against each other. His daughter, Shannon, has sued his son, KC, um, for lots of different reasons, and actually some caregiver and also a business associate for elder abuse. They said that the will wasn't good, that either he lacked capacity when he signed the will, and that, or there was undue influence. There had been, she has been suing her brother for before the dad died for abuse, saying he was neglected. Uh, John Amos did have Lewy body dementia. There's lots of different types of dementia. Lewy body, Parkinson's dementia, they're kind of the same family. It's just a matter of when, about movements as well as the dementia itself is affected. Of course, Alzheimer's, and I want to thank those who attended the walk, the Alzheimer's walk this year. If you haven't, if you did go, and if you didn't go, join us next year. So there's lots of different types of dementia. He happened to have Lewy body dementia. Um, the question is was he diagnosed too? Well, anyway, the story of John Amos was his son was taking care of him, and he also had a caregiver. Um, and she had sued him before, thinking that there was elder abuse. There was times where she alleged that he had isolated the dad from others, and his foot got infected. There was maggots in the foot, but apparently, um, sometimes they use that to take away, I think, some of the issues with that. I think that sometimes maggots are used, but I don't know for a fact. I'm not in the medical area. But anyway, that's what she alleged. He had lived in both, I think, the Denver area, or at least in Colorado and in California. And the complaints previously had been dismissed by the uh, legal authorities, that is, the police or whomever that she complained to. So, but then when before he passed, the caregiver um, noticed that he had an abdominal pain, and she waited for a bit and took him to the hospital, and he died, at least under the death certificate, of a heart attack. Now, when she was at the hospital, she said that she was the daughter, even though she wasn't the daughter of John Amos. So she's been sued by Shannon, saying, you know, first of all, why did you wait so long? And he had dementia. Why does the death certificate say heart attack? I
Right.
debate that, but the doctors say it was a heart attack. So she's suing for elder abuse and for also for the fact that did he have capacity when he signed the will? Well, or was there undue influence? So how do you determine if you have capacity? How do you determine that? Well, that's not easy.
Oh,
And just because you've been diagnosed with a dementia doesn't mean that you don't know who the bounty of your affection is. Bounty of your affection is like who your loved ones are. Don Crawford, bounty of my affection is Sarah, my spouse. Who who would you normally give things to? Do you have a rough idea what your assets are? A lot of times what we do is we have a doctor who specializes in the mind, let's say a neurologist or a geriatric psychiatrist, sign a capacity affidavit. And if they don't sign it, and we just had one just literally just an hour ago, and the doctor said no capacity for the husband. So we did not do documents for him. Well, we
Wow.
prepared documents, but we wouldn't let him sign it. We
Wow.
said, there's not, in fact, if we don't feel like it's something that is right, we're just not going to permit the signing of the document. So if you don't know what you're signing, you shouldn't be signing.
I find that fantastic. Typical you, and I've known you for 12 or 13 years now. And that's the integrity that I've always known about you and proclaimed about you with people on the air, in the community, et cetera, et cetera. So none of that surprises me because you have ethics and values. I'm not sure all attorneys do.
Well, I can't speak for anybody else. All I could say is if we think that there's a question as to capacity, we usually get a doctor to sign an affidavit. And we also recommend that the doctor be specialized in that area. So we prefer not to have a general practitioner because, you know, or let's say you had a podiatrist. Do they really know about what your mind is if you have enough capacity? No,
Right?
with all due respect to podiatrists. They're specialized in their area and others are specialized in their area. And the other thing is undue influence. Is there undue influence? Well, so was he with his dad at the time that the will was signed? If so, there could have been undue influence. Did he take him there? Did he pay for the preparation of the will? If he had a weakness of the mind, see, she wants to be the executor. She wants to freeze the assets. She wants to be in control. So often, it's more about who wants to be in control. We had a case that I think I may have mentioned maybe on the last recordings, or last one of the times we did, maybe last month sometime, uh, where we had something where the will says all equally to the four children, but one of the children contested. It wasn't necessarily about the fact that she wanted more than the others. She just wasn't named as the executor. She wanted to be in control, so she contested the will. Now, the problem with that is that she runs the risk of one fourth in her case being excluded from her. She doesn't get it because there was a no contest provision. So in every will or trust, we always have a no contest provision. But the question then also becomes, was let's say somebody who's a beneficiary in the room with whoever is signing, and did they get something that maybe they shouldn't have gotten? So let's say that KC was with the dad at the time that Dad, John Amos, signed his will. It could be argued that there was undue influence, especially since he had a dementia. There was some weakness of the mind. He could have unduly influenced.
He could have been unduly influenced weeks and months prior to even going to meet with the
Could,
attorney.
could have, could have. You never know. Did he abuse his dad by isolating him? I don't know. It depends on the facts.
Right.
You'd have to find out more. Did he want to socially uh, keep him away for various reasons? Maybe he was fearful that something dad may do or not do. I don't know. Uh, her claims for elder abuse had been dismissed before, so I'm not so sure about that. But we do know this. It should be easy for the doctors to determine when somebody had Lewy was diagnosed. And furthermore, you should have medical records to see how they progressed in that dementia. So that should be pretty easy to find. And since once you find that out, then let's say that he still had capacity, then it's just a matter of the undue influence. Those are the two biggest things that people do when they contest a will. Although I know that she would like to uh, obviously be in control and be the executor as well. So I guess the lesson to be learned is is the estate planning attorney. Well, how bad is the dementia? Make sure that the person is separated and that there's no undue influence. And try to find out about the family dynamics too. A lot of times, if we had a situation where we thought it might be more difficult with a will, it's easier to contest, at least in our mind. Other estate planning attorneys may disagree because if you don't probate a will, if it's just in the trust, it's just already in a trust. And so that means that it'd have to be an affirmative action, Shannon, whereas on a will contest, you could just say, I contest, basically, and hold things up in court.
That's
So,
tough. Yeah, that's really disappointing, but I guess anybody can challenge it. And if they do, then they're going to deal with the consequences. And it almost seems, Michael, since you brought this back up, that it's almost standard now that if anybody challenges it, you're gone. You're written out of the will. Is that correct? Or the estate plan?
not really. You could challenge a will and not, it could be for other reasons. Oh, the executors, this or that. And so, a lot of times it's not that you're automatically cut out.
I
Uh,
see.
so, so there could be other reasons. So you have to prove a lot of other stuff before you could just be cut out.
Right.
So it
I
just depends
appreciate
on
this
things.
show, this program, this podcast greatly because I learn so much every time I talk to you, whether it's 5 minutes or 35 minutes, whatever the case, and this is no exception. It creates and generates more questions for me, makes me think about my situation, and it should make the viewers think about theirs. And the way to get those answers is to attend the next workshop, which you provide for free in person at your offices on a Saturday. The next one is probably December the 6th, Saturday the
Yeah,
6th.
it depends on when you're listening to this.
Right.
So if there's any question, if you want to go to the free estate planning essentials workshop, it's no obligation. It's all you have to do is call 214-720-0102 or sign up online at dallaselderlawyer.com, dallaselderlawyer.com. Or again, that phone number is 214-720-0102. This is It's just about whatever questions you want to know. We ask people what they want to know. So as we get to the holidays and we think about the coming year, a lot of times people say, "Oh, gee, I didn't realize this may be time to think about the future." So
Especially if you're going to get together with family over the
yeah,
holidays.
yeah,
Now is the time.
yeah. Whether it's Thanksgiving or Christmas or whatever the situation may be, it's probably a good time to reevaluate. And just because, just even if you had a will or a trust, maybe things have changed. Sometimes people get married, sometimes people get divorced, sometimes people get disabled, sometimes people have creditor issues, sometimes they have marital problems. Like I said, sometimes it's all sorts of different things that could occur in life. And so, and as we age, because people get disabled more often as we age, then it should be reviewed at least more often than if you're younger.
Agreed.
So hopefully some of y'all will join that free estate planning essentials workshop and join us and see whatever questions you might have.
Thank you, Michael.
Thank you.